Good day, ma'am. I am Bahinting Larry M., your student in CA 200 Section A, Institutional Correction. So today, I'm going to discuss and present the fourth module. So these are the lesson. Institutional-based correction, structures, management, standards, programs and services in the Philippines. Two system-based approaches to corrections. The Bureau of Corrections, Republic Act 10575, Custody, Security and Control of Prisoners, Care and Treatment of Prisoners, Release of Prisoners, Good Conduct, Time Allowance or GCTE, Prohibited Acts subject to disciplinary action, Video-Ppt, Republic Act 6975, Republic Act 9263. Treatment of special needs or unusual offenders, emergency plans, movement, transfer of prisoners, detainees, privilege of detainees and sentenced prisoners, the Regional Rehabilitation Center for Youth, the Child and Youth Welfare Code, the death row, and the role on the writ of amparo. So institutional-based correction means that the individual is placed in a prison or jail, which means they are housed in a secure correctional facility. Correction is a branch of the criminal justice system concerned with the custody, supervision, and rehabilitation of criminal offenders. Institutional-based correction structures, management, standards, program, and services in the Philippines. So, institutional-based correction. There are two bureaus that implements institutional-based correction. The Department of Justice and the Bureau of Jail Management and Penology. Structure. In 2020, the imprisonment rate was 358 per 100,000 US resident, the lowest since 1992. Majority of these prisoners were located in jails in the National Capital Region. Management. The Department of Justice or DOJ and Department of the Interior and Local Government or the DILG are the two departments of the Philippine government that supervise the Bureau of Correctional-based correction, institutional-based correction. The Department of Justice or DOJ supervise the Bureau of Corrections or BUCOR, which is responsible for the custody of the insular or national prisoners. The programs of correction that is used in the Philippines are absolute pardon, conditional pardons, commutation of sentence, amnesty, and parole. Absolute pardon is the total extinction of the criminal liability of the individual to whom it is granted without any condition whatsoever, resulting to the full restoration of his civil rights. Conditional pardon. A pardon is conditional when its effectiveness depends on fulfillment of a condition by the offender. The Constitution gives to the President the power to grant reprieves and pardons for offenses against the U.S. This power to grant a pardon includes the power to grant a conditional pardon. Commutation of sentence. It is the reduction of the period of a prison sentence. Amnesty and official pardon for people who been convicted in political offenses. Parole is a conditional release of prisoners before they complete their sentence. Parole prisoners are supervised by a public official, usually called a parole officer. If a parole prisoners violate the condition of their release, they may be returned to a prison. Programs and services. Prison education, the cornerstone of rehabilitation. It is the process or result of formal training in scholar or classrooms intended to shape the mind and attribute of prisoners toward good living upon their release. Classes of prison education. A general and academic education, the objectives of which is to eradicate literacy among prisoners. Vocational education, the purpose of which is to provide prisoners necessary skills and successful work in a socially acceptable occupation after their release. Auto mechanics, shoemaking, tailoring, and carpentry. Physical education. Work programs. It is purposely to eliminate idleness on the part of prisoners, which may contribute to prison's stupor, and it affects the incidence of prison riots. Religious service in prison. The purpose of this program is to change the attitude of inmates by inculcating religious values or belief. So, recreational programs, medical and health services, counseling, and casework. Two system-based approaches to corrections. First is institutional-based correction. Second is community-based correction. Institutional-based correction means that the individual is placed in a prison or jail. Community-based correction means you are in either placed on parole or given probation. Numerous programs are utilized in order to place offender into a community to serve their sentences. Under community-based correction, numerous programs are utilized in order to place offenders into the community to serve their sentences. These offenders are typically non-violent, low-level criminals. The idea behind community-based correction is that successful rehabilitation of offenders can only occur in the real world. Moreover, the policy behind community correction is that offenders will subsequently return to the real world. So, it's appropriate to try and provide rehabilitation in the community. Advantage of community-based correction from institution. Community corrections program offered some distinct advantage. The first is a cost issue. Compared to jail and prison, most community program cost less. Offenders live at home and in the small number of residential programs where the offenders live at the facility. They help subsidize the cost of living. A community-based correction effective. According to these studies, community-based correction are a cost-effective way to provide alternative to incarceration. If community can be shown to be at least as effective as prisons, but cheaper, then such strategies should be adopted. The three main advantage of community-based correction. Community Community corrections program attempt to accomplish many goals. Second, these goals include easing institutional crowding and costs. Third, preventing future criminal behavior through surveillance, rehabilitation, and community reintegration, and addressing victims' needs through restorative justice. The correctional system in the Philippines is composed of 6 agencies under 3 distinct and separate departments of the national government. The 3 departments of the national governments are the first is the Department of Justice, second is the Department of the Interior and Local Government, and the third is the Department of Social Welfare and Development. The Department of Justice takes of the national prisoners, the national prisons and penal farms, which is being supervised and administered by the Bureau of Corrections or BUCOR. This headed by a civilian director, tasked to rehabilitate national prisoners so they can become useful members of society upon completion of their sentence. Bureau of Correction is an agency of the Department of Justice which is charged with the custody and rehabilitation of national offenders who have been sentenced to 3 years of imprisonment or more. The agency has its headquarters in the New Bilibid Prison Reservation in Muntinlupa. The national prisoners is also referred to under the law as insular prisoners. Bureau of Correction mandate the rehabilitation of the national prisoners. Bureau of Correction slogan, bringing back to the dignity of man. And the Bureau of Correction principles, accomplishing its mandate objectives and performing its assigned functions. To confine prisoners by giving them adequate living spaces as the first condition to be met before any effective rehabilitation program can be undertaken. To prevent prisoners from committing crime while custody. To provide human treatment by affording the human basic needs in the prison's environment and prohibiting cruel methods and provide a variety and rehabilitation program. So the Bureau of Corrections operating institutions. So first, New Bilibid Prison in Muntinlupa City. Second, Correctional Institution for Women in Mandaluyong City. Iwahig Prison and Penal Farm in Puerto Princesa City. Fourth, Davao Prison and Penal Farm in Davao del Norte. Fifth, Sablayan Prison and Penal Farm in Occidental Mindoro. Sixth, San Ramon Prison and Penal Farm in Zamboanga City and Leyte, and Leyte Regional Prisons in Leyte. So it's an institutional program. Number 1, inmate work program. Second, healthcare. Third, education and skills training. Fourth, recreation and sports. Fifth, religious guidance behavior modification using the therapeutic community approach. Republic Act number 10575, an act strengthening the Bureau of Correction or BUCOR and providing funds therefore, be it enacted by the Senate and House of Representatives of the Philippines in Congress assembled. Section 1. Short title. This act shall be known as the Bureau of Correction Act of 2013. Section 2. Declaration of Policy. It is the policy of state to promote the general welfare and safeguard the basic rights of every prisoners incarcerated in our national penitentiary. It also recognizes the responsibility of the state to strengthen government capability aimed towards the institutionalization of high efficient and competent correctional services. Section 3. Definition of terms. A. Safekeeping, which is the custodial component of the Bucor's present corrections system, shall refer to the act that ensures the public, including families of inmates and their victims, that national inmates are provided with their basic needs, completely incapacitated from further committing criminal acts, and have been totally cut off from their criminal networks for contracts in the free society while serving sentence inside the premises of the National Penitentiary. B. Reformation, which is the rehabilitation components of the Bucors. Present corrections system shall refer to the acts which ensure the public, including families and inmates and their victims, that released rational inmates are no longer harmful to the community by becoming reformed individuals prepared to live a normal and productive life upon reintegration to the mainstream society. Section 4. The mandate of the Bureau of Correction. The Bucor shall be in charge of safekeeping and instituting reformation programs to national inmates sentenced to more than 3 years. A. Safekeeping of national inmates. The safekeeping of inmates shall include decent provision of quarters, food, water, and clothing in compliance with established United Nations standards. B. Reformation of national inmates. The reformation programs which shall be instituted by the Bucor for the inmates shall be the following. First, moral and spiritual programs. Second, education and training programs. Third, work and livelihood program. Fourth, sports and recreation program. Fifth, health and welfare programs. And sixth, behavior modification program to include therapeutic community. C. The reformation program shall be undertaken by professional reformation personnel consisting of corrections technical officer with ranking system and salary grades similar to corrections officers. 1. Correction technical officer are personnel employed in the implementation of reformation program and those personnel whose nature of work requires proximate or direct contact with the inmate. Corrections technical officer includes priests, evangelists, pastors, teachers, instructors, professors, vocational placement officer, librarians, guidance counselors, physicians, nurses, medical technologists, pharmacists, dentists, therapists, psychologists, psychiatrists, sociologists, social workers, engineers, electricians, agriculturists, veterinarians, lawyers, and similar professional skills relevant to the implementation of inmate reformation programs. Section 5. Operations of the Bureau of Corrections. A. The Bucor shall operate with a directorial structure. It shall undertake reception to inmates through its Directorate for Reception and Diagnostic o DRD, formerly Reception and Diagnostic Center or RDC, provides basic needs and security through its Security and Operations Directorate, administer reformation programs through its reformation directorates, and prepare inmates for reintegration to mainstream society through its Directorate for External Relation or DER, former External Relation Division or ERD. B. The DRD shall be responsible for the conduct of classification of each and every inmates admitted to the Bucor. Inmates shall be classified according to security, race, and sentence. Aside from those born of the provision under Rule 8, Part 1, Rules of General Application of the United Nations Standard Minimum Rules for the Treatment of Prisoners, and that of the existing regulation of the Bucor on security classification. D. From the DRD, the custodial force and reformation personnel of respective security institutions camps shall be in charge for the security and the implementation of the recommended inmate reformation program of each and every inmate while serving sentence respectively. E. The Directorate for External Relations or DER shall be responsible for pre-release and post-release program of inmates due for release. If, apart from handling inmates, the Bucor shall administratively operate like a standard government agency through its administrative directorates with internal control and internal audit units. The Bucor shall employ full computerization in the build-up, maintenance, and transmittal of necessary inmate records to all its prison and penal farms and other recipient agencies or Board of Pardons and Parole. Section 6. Lands of the Bureau of Correction. A. Aside from administrative purposes, all Bucor lands shall be used for inmate security, reformation programs, and as a means to promote sustainability both for income and non-income generating programs with or without partnership among non-government organization, civic organization, or other government entities. B. As a way to maximize its assessed value for the effective and extensive reformation programs for national inmates, the Bucor shall have the absolute authority to design, formulate, and implement land use development plans and policies. C. The Bucor may propose additional penal farms as may be necessary as possible. Aside from its existing 7 prison of penal farms, to decongest existing penal institution and accommodate the increasing number of inmates committed to the agency. D. All Bucor lands shall have a certificate of title registered under its name. Section 7. Facilities of the Bureau of Corrections. The Bucor shall operate with stands and uniform design of prison facilities, reformation facilities, and administrative facilities through all the operating prison and penal farms, such as following. A. Dormitory. B. Administration building. C. Perimeter or security fences. D. Hospital or infirmary. E. Recreation or multipurpose hall. F. Training or lecture center. G. Workshop facility. H. Mess hall or kitchen. I. visiting area. J. Water tank and jump. K. Reception and diagnostic center. And L is service personnel facility. Section 8. Supervision of the Bureau of Correction. The Department of Justice or DOJ, having the Bucor as a line bureau and constituent unit, shall maintain a relationship of administrative supervision with the latter and defined under Section 38. Section 9. Organization and key position of the Bureau of Corrections. A. The Bureau of Correction or Bucor shall be headed by a director who shall be assisted by 3 deputy director, 1 for administration, 1 for security and operation, and 1 for reformation, all of whom shall be appointed by the President upon the recommendation of Secretary of the DOJ. Section 10. Increase of personnel. The Bucor shall maintain the custodial personnel to inmate ratio of 1:7 and reformation personnel to inmate ratio of 1:24. Hence, is authorized to increase its manpower to meet such ratio and may continue to increase personnel per percentage rate increase of committed inmates annually or as the need arises. Section 11. Professionalization and upgrading of qualification standards in the appointment of the Bucor personnel. A. No person shall appointed as personnel of the Bucor unless one possesses of the following maximum qualification. 1. A citizen of the Republic of the Philippines. 2. A person of good moral character. 3. Must have passed the psychiatric, psychological, drug, and physical tests for the purpose of determining his or her physical and mental health. 4. Must possess a baccalaureate degree from a recognized learning institution. 5. Must possess the appropriate civil service eligibility. 6. Must not have been dishonorably discharged or dismissed for cause from previous employment. 7. Must not have been convicted by final judgment of an offense or crime involving moral turpitude. And 8. Must be at least 1 meter and 62 centimeters or 1.2 centimeters in height for male and 1 meter and 57 centimeters for female, provided that a waiver for height and age requirements may be granted to applicants belonging to the cultural communities, provided further that new applicants must not be less than 21 or more than 40 years of age. So B. After the lapse of the period for satisfaction as a specific requirements incumbent personnel of the Bucor who fails to satisfy any of the requirements enumerated under this section shall be separated from the service if they are below 50 years of age and have served in the government for less than 20 years, or retired if they are 50 years and above, and have served in the government for at least 20 years without prejudice in either cases to the payment of benefits they may be entitled to under existing laws. C. For sustained professionalism in the services, the Bucor is directed to conduct study for the feasible establishment of the Philippine Corrections Academy, patterned after the Philippine National Police Academy or PNPA of the Philippine National Police or PNP and the Philippine Military Academy or PMA of the Armed Forces of the Philippines or AFP for its commissioned officer. D. The Bucor shall continue training its personnel through its personnel training school, which shall be renamed as Corrections Training School or Institute patterned after the BGMP Jail National Training Institute or GNTI, the Bureau of Fire National Training Institute or FNTI, and the PNP National Training Institute or PNTI. Section 12. Appointment of personnel to the Bucor. The appointment of the Bucor shall be effected in the following manners. A. Corrections Officer 1 to Correction Chief Superintendent. Appointment by the Director General of Corrections and attested by the Civic Services Commission or CEC. And B. Director General of Correction and Deputy Director of Corrections, appointed by the President upon the recommendation of Secretary of the DOJ with the proper endorsement by the Chairman of the CEC. So, custody, security, and control of prisoners. Custody of prisoners. Admission of prisoners. The formal correctional process begins from the time the accused is convicted, whether he is to serve time for violating or ordinance, in which cases he would serve his sentence in local jails, or the revised penal code, in which case he would be sent to the National Penitentiary to serve his penalty. Spending time in jail or being locked up while awaiting conviction is not a formal entry to the correctional system, yet and therefore the accused's presumption of innocence remains as it was, and he must be handled and treated as such unless the accused files a request for working detention. He cannot be compelled to don the prison, jail uniform, nor subjected to the regimen an ordinary prisoner undergoes while under confinement. In the event the accused is convicted for violating the revised penal code and the other special laws, and is given a sentence with a maximum period of more than 3 years, he is to be transported to the National Penitentiary within a period of 60 days. This period is to be reckoned on the date of the commitment order as issued by the court. Correctional authorities must be guided by and observe in due course the following. The custody of the prisoners differs on the gravity, severity of the crime committed. If a convicted criminal commits a crime that has a sentence of more than 3 years, he or she is under the custody of the Bucor. If a convicted criminal commits a crime that has a sentence of 6 months to 3 years. He or she is under the custody of the provincial government. If a convicted criminal or an offender undergoing trial of crime that has a sentence of 1 day to 3 years, he or she under the custody of BGMP. Security and control of prisoners. The backbone of the correctional facility is good security. As a matter in fact, every aspect of custodial concern relates to security. If there is an operational area which marks the difference between prison custody and police security as a role in dealing with violation, it lays mainly in their rules of engagement. If a prisoner poses a challenge at corrective. Release of prisoners. Prisoners are released from confinement for any of the following reason. A. Upon expiration of his sentence. B. By order of the court or of competent authority. C. After being granted parole, pardon, or clemency or amnesty. In the matter of executive clemency and parole cases, the Director of Corrections submits the inmate's prison records to the Board of Pardon and Parole within the following period. For commutation of sentence, at least 1 month before the expiration of 1/3 of the minimum period of the inmate's indeterminate sentence, and in special cases at least 1 month before the periods specified by the board. For conditional pardon, at least 1 month before the expiration of 1/2 of the minimum period of the inmate's determinate sentence, and in special cases at least 1 month before the periods as the board may specify. For parole, at least 1 month before the expiry date of his minimum sentence. Pre-release and post-release program. The Directorate for External Relations or DER shall be responsible for pre-release and post-release programs of inmates due for release. The DER shall also evaluate, classify, and apply necessary reformation programs to inmates for readiness to join the mainstream society upon release as part of the pre-release program. The inmate readiness programs are customized towards their specialization in the areas of educational growth, livelihood, entrepreneurship, sports engagement, religious practice, and appropriate medical treatment. This specialization is intended for the continuous practice of inmates in these areas in the free society through linkage, liaison, and coordination efforts undertaken by DR with the appropriate agencies, institutions participating in post-release programs such as government or private schools, churches, health centers, government or private hospitals, and local government units. The DER shall also classify inmates according to professional, technical, and vocational skills acquired for referral and endorsement to appropriate companies or corporations participating in BioCor on-the-job training and skills development programs for newly reformed inmates. The conduct of post-release programs by DER includes monitoring and evaluation of performance of released inmates on their specialized areas among the participating agencies or institutions in the free society to assess the effectiveness and applicability of reformation programs institutionalized by Bucor. In order to fully implement a successful reintegration of released inmates to the community, the following circumferential objectives are to be focused upon by Directorate for External Relations or DER. To wit, first, secure support from family and community prior to release period and secure acceptance from family and community upon release. The authority to release. Those authorized to order or approve the release of inmates are A. Supreme Court or the lower courts in cases of acquittal or grant of bail. B. The President of the Philippines in cases of executive clemency or amnesty. C. The Board of Pardons and Parole in parole cases. D. The Director of Corrections upon the expiration of the sentence of the inmate. Separation and Placement Center. A facility called the Separation and Placement Center is maintained for prisoners to be released. Those who scheduled date of release shall be issued within 30 days. It is here where the prisoner is cleared of his government property accountability. Good Conduct Time Allowance or GCTA. Republic Act 10592 or the Good Conduct Time Allowance or GCTA law allows for a reduction of sentence of persons deprived of liberty depending on how well they abide by rules and regulations inside any penal institution, rehabilitation or detention center or any other local jail. This law is relation to Republic Act 7659 Death Penalty Law. Reported does not cover PDL who have been convicted of heinous crimes as enumerated in RA 7659. These crimes were considered punishable by death for being grievous, odious, and hateful offenses and which by reason of their inherent or manifest wickedness, viciousness, atrocity, and perversity are repugnant and outrageous to the common standards and norms of decency and morality. How is the GCTA computed? In Section 3 of Republic Act 10592 provides the guidelines for calculating the GCTA of inmates. First, for the first 2 years of imprisonment, for each month of good behavior, 20 days will be deducted from the total sentence. If a convict behave well each month, 480 days or roughly 1 year and 3 months will be conducted from his prison term. Second, for the 3rd to 5th year, for each month of good behavior, 23 days will be deducted, or a total maximum deduction of 828 days, or roughly 2 years and 3 months from the prison term. Third, for the 6 months to 10 years, 25 days for each month of good behavior, or a total deduction of roughly 1,800 days, or roughly 4 years and 1 month from the prison term. Fourth, for the 11th and successive years, a month of good behavior equals a 30 days deduction. This means that a person serving 25 years who will behave every month from his 11 to 25 years would get a prison term reduction of 14 years and 7 months. Fifth, in addition, an inmate shall get 15 days additional reduction for each month of study, teaching, or mentoring services. This means that a PDL who has been in jail for 25 years and who showed good behavior during imprisonment can have as much as 19 years deducted from his or her jail term. So, prohibited acts subject to disciplinary action. First, unauthorized selling or bartering with fellow PDL of items not classified as contraband. Second, unauthorized rendering of personal services to fellow PDL. Third, littering or failing to maintain cleanliness and orderliness in quarters and or surroundings. Fourth, making frivolous or groundless complaints. 5. Taking the cudgels for reporting complaints on behalf of other PDLs. 6. Let information during PDL hit counts without justifiable reason. 7. Willful waste of food. 8. Failure to report for work without sufficient justification. 9. Failure to render assistance to an injured personnel or fellow PDL. 10. Failure to assist in putting out fires inside the prison. 11. Behaving improperly or acting boisterously during religious, social, and other group functions. Swearing, cursing, or using profane or defamatory language directed at other persons. 13. Malingering or pretending to be sick to escape work assignment. 14. Spreading rumors or malicious introduce to besmirch the honor of any person. 15. Failure to stand at attention and give due respect when confronted by or reporting to any person of authority. 16. Forcing fellow PDL to render personal services for him or her and or to others. 17. Exchanging uniform or wearing clothes other than those issued for the purpose of circumventing jail's rules. 18. Littering or being in an unauthorized place. 19. Unauthorized use of communication equipment. 20. Writing, defacing, or drawing on walls, floors, or any furniture or equipment. 21. Withholding 21. Withholding information which may be inimical or prejudicial to prison security. 22. Possession of lewd or pornographic literature, photographs, and sexual items. 23. Absence from cell, brigade, place of work during head counts or at any time without justifiable reason. 24. Failure to turn over any employment article issued after work detail. 25. Making untruthful statements or lists in any official communication, transaction, or investigation. 26. Keeping or counseling case or lacks of place in the prison which are off limits to PDLs. 27. Giving gift, selling, or bartering with any prison authority. 28. Keeping unauthorized amount of money, jewelry, cellular phones, or other communication device, luxurious properties, and other items classified as contraband under the rules. 29. Tattooing others or allowing him or her to be tattooed on any part of the body or keeping paraphernalia to be used in tattooing. 30. Forcibly taking or extorting money from fellow PDL or visitors. 31. Punishing or inflicting injury or any harm upon him, herself, or other PDL. 32. Receiving, keeping, taking, and drinking liquor and prohibited drugs and smoking. 33. Making, improvising, or keeping any kind of deadly weapon. 34. Concealing or withholding information on plans of escape. 35. Orally conduct and flagrant disregard of discipline and instructions. 36. Escaping, attempting, or planning to escape from the institution or from any guard. 37. Helping, aiding, or abetting others to escape. 38. Fighting, causing any disturbance or participating therein and or agitating to cause such disturbance or riot. 39. Incident, immoral, or lascivious act. 40. Willful disobedience to a lawful order issued by any person authority. 41. Assaulting any prison personnel. 42. Damaging any government property or equipment. 43. Participating in kangaroo court and unauthorized or irregular court conducting with disregard for perversion of legal procedures as mock court by the PDL in prison. 44. Failing to inform the authorities concerned when afflicted with any communicable disease such as tuberculosis, sexual transmitted disease, and etc. In 45. Engaging in gambling or any game of chance. 46. Committing an act which is an violation of any law or ordinance. 47. Committing an act prejudicial to good order and discipline. 48. Any behavior which might lead to disorder or violence or such other actions that may endanger the facility, the outside community, or others. 49. Any act analogous to the foregoing. So, let's move to BJMP Republic Act 6975. On January 2, 1991, the Bureau of Jail Management and Penology was created through Republic Act 6975 as a line bureau under the Department of Interior and Local Government. The Jail Bureau is the upgraded version of its forerunner, the Office of Jail Management and Penology of the defunct PC or INP, last headed by Brigadier General Arsenio A. Concepcion. As mandated by law, the BJMP shall operate under the reorganized Department of the Interior and Local Government or DILG. Starting from scratch with 500 personnel in 1991, the BJMP went from its mother PC or INP as a mere component to become a full-fledged bureau. Director Charles S. Mundihar took his oath of office on July 1 of 1991 as the first chief of the bureau. The Bureau of Jail Management and Penology supervises and controls all district, city, and municipal jails. Republic Act 9263, an act providing for the professionalism of the Bureau of the Fire Protection or BFP and the Bureau of Jail Management and Penology or the BJMP, amending certain provision of Republic Act 6975. It is declared policy of the state to maintain peace and order, protect life, liberty and property, and promote the general welfare as essential for the enjoyment by all the people of the blessing of democracy. Article 2, Section 5 of the Philippine Constitution. It is provided for under Republic Act number 6975, otherwise known as the Department of Interior and Local Government Act in 1990, that the task of fire protection and jail management and penology shall be the responsibility of the Bureau of Fire Protection or BFP and the Bureau of Jail Management and Penology or BJMP respectively. Over Section 3 of the Republic Act number 8551, otherwise known as the Philippine National Police Reform and the Reorganization Act of 1998, provides that in times of national emergency, BFP and the BJMP, along with the Philippine National Police or PNP, shall, upon the direction of the President, assist the Armed Forces of the Philippines or AFP in the meeting the national emergency in addition to performance of their inherent function as mandated by law. It is therefore recognized that the uniformed personnel of the BFP and the BJMP as member of the uniformed services of the government under the Department of Interior and Local Government or the ILG are required the same amount of sacrifice, services and dedication like their counterparts in the PNP and the AFP to carry out their respective duties to the extent of risking their lives and limbs. Treatment of special needs or unusual offenders. Special needs offenders are incarcerated offenders with special needs stemming from their physical or mental age or other disabilities. Special needs can encompass many types of conditions like A. Offenders with severe psychological needs, mental retardation, significant psychiatric disorder, behavior disorder, multiple handicaps, neurological impairment, and substance abuse, or B. Offenders with physical handicaps or chronic or terminal illness, or elderly offenders, or C. Offenders with severe social and or educational deficiencies, learning disabilities, or language barriers, or offenders with special security or supervision needs such as protective custody cases, death row inmates, and those who chronically exhibit potential or aggressive behavior, or sex offenders for whom appropriate treatment may reduce the risk of reoffending. Basic policy. As a general rule, inmates with special needs should not be held in jails with other regular inmates. For example, female inmates should be confined in institutions separate from those used for males, and male youth offenders should not be mixed with adult offenders. However, given the reality relative to budget constraints, increasing inmates population in sufficient facility, and inadequately equipped determined homes, wardens and jails officers shall endeavor to provide the best arrangement they can make for such inmates. In keeping with this rule, it is assumed that the inmates have been properly evaluated and classified for these purposes. Handling inmates with special needs. The following guidelines shall be observed in handling inmates with special needs. First, female. The female dorm should be completely separated from the male dorm. A female personnel shall be designated to keep the case of the female dorms only work suitable to their age and physical condition should be assigned female inmates. D. No male inmate shall be allowed to enter female dorms. E. Male personnel must provide female inmate with utmost privacy and respect for personal space. If no male jail personnel should be allowed to enter the female dorm except in emergency cases or when necessary. G. Searches shall be performed by a female personnel trained in the conduct of appropriate searching methods shall be made in accordance with established rules and shall be provided with privacy during the procedure. H. Medical or physical examination shall be performed by female health personnel. In the absence of the female health staff, the examination shall be performed by a male health personnel in the presence of a male staff, and female inmates shall be provided with the opportunity to avail themselves of all programs and activities male inmates are provided with. Second, drug users or dependents or alcoholics. E. Inmates found to be drug users, dependents, alcoholics should be segregated from other inmates, especially during the withdrawal period. B. Inmates undergoing drug alcohol withdrawal must be referred to the jail psychiatrist, physician, or nurse for evaluation, and management. C. Appropriate measure should be taken to enable inmates to follow strictly the jail physician advice regarding diet and other medical interventions, treatments during the withdrawal period. Maintain close supervision over inmates to prevent attempt to commit suicide or self-mutilation by designating a jail personnel trained to manage such cases. And E. Conduct a regular search of the inmates' dorm and maintain constant alertness to prevent the smuggling of narcotics, liquor, and other dangerous drugs. 3. Mentally ill. E. Inmates manifesting signs and symptoms of mental illness must be referred to the jail psychiatrist for evaluation and treatment. B. Disturbed inmates. Mentally ill inmates should be transferred to mental institution for proper psychiatric treatment upon the issuance of a court order. C. Close supervision and medical management of mentally ill inmates should be maintained by a jail medical personnel. D. Place the mental ill inmates in separate dorms or in a special restraint rooms provided for violent cases, and maintain close supervision over inmates to guard against suicidal attempts or violent attacks on others. 4. Lesbian, gay, bisexual, or transgender or LGBT. Segregated LGBTs to prevent their maltreatment and abuse by other inmates and to prevent them from maltreating and abusing other inmates. 6. Offenders. Inmates charged with sexually released crime should be segregated to prevent them from taking advantage of other inmates and maintain close supervision and control. 6. Suicidal inmates. Inmates manifesting signs and symptoms of depression, suicidal tendency must be referred to the jail psychiatrist for evaluation and management. An inmate who attempts to commit or has attempted to commit suicide must be transferred to a government psychiatric hospital immediately upon issuance of court order. Maintain close supervision over suicidal inmates at the times and designate personnel trained to handle such cases and subject them to frequent strip searches and greyhound operation for tools, materials that can be used for suicide. 7. 6. Deviates. Homosexuals should be segregated immediately to prevent them from influence other inmates of being maltreated or abused by other inmates, and likewise other 6 deviates should be separated from other inmates for closer supervision and control. 8. Escape-prone inmates. Escape-prone inmates should be held in the most secure quarters, preferable by single inmate cell, to minimize their contact with one another. Their conduct behavior should be closely watched, observed during and after visiting hours, and their activities closely mentioned. These should be frequently strip searched and their quarters frequently inspected. Special attention should be given to to the examination of items recovered from strip searches, and telephone calls must be restricted and only calls that can be monitored through an extension line shall be allowed. 9. Inmates with disability. Inmates with disability should be segregated and closely supervised to protect them from maltreatment and any form of abuse by other inmates, personnel, and visitors. Individual cases management and special activities should be developed and conducted to address this strength of the inmates. Collaboration with other government agencies should be done to ensure that disabled inmates are provided with the service and benefits contemplated under the Magna Carta of Disabled Persons, and tasks related to self-care of inmates with disability shall be supervised and assist to avoid potential self-harm or accidents. 10. Children in conflict with the law, o CICL. Pursuant to the Republic Act 9344, CICL shall not be confined in jails. Hence, serious efforts shall be exerted by warden to immediately transfer the custody of the CICL to a youth detention home or youth rehabilitation center. 11. Senior citizen inmates. Senior citizen inmates should be segregated and close supervised to protect them from maltreatment and other forms of abuse by other inmates. Individual case management strategies should be developed and adapted to respond to the special needs of elderly inmates. Collaboration with other government agencies and community-based senior citizen organizations should be done to ensure that the services due the senior citizen inmates are provided, and senior citizen inmates should be made to do tasks deemed fit and appropriate their age, capability, and physical condition considered. 12. Infirm inmates. Inmates with contagious disease must be segregated to prevent the spread of the said contagious disease. Infirm inmates should be referred to the jail physician or nurse for evaluation and management, and infirm inmates must be closely monitored and provided with appropriate medication and utmost care. 13. Pregnant inmates, female inmates with infants. Pregnant inmates must be referred to jail physician or nurses for prenatal examination. They should be given tasks that are deemed fit and proper their physical limitations considered. During active labor, pregnant inmates should be transferred nearest government hospital. Treatment of mother and her infant shall be in accordance with the BGMP policy refers to the DIWD manual, and female inmates with infants shall be provided with ample privacy during breastfeeding activity. 14. Inmates of other nationalities. The warden shall report in writing to Bureau of Immigration and the respective embassies of the detained foreigners the following: name of jail, name of foreigner, nationality, and the number of his or her alien certificate of registration if any. 6. Age, 6. Offense charge, case number, court or branch, status of cases, and additional data information. Emergency plan movements, transfer of prisoners or detainees. Emergency plans for both natural and man-made calamities and other forms of jail disturbance jail shall be formulated as to suit the physical structure and other factors peculiar to every jail, such as natural calamities, fire, flood, earthquake, tsunami, landslide, typhoon, volcanic eruption, epidemics, and others. Man-made calamities or disturbance, riot, jailbreak, noise barrage, hostage taking, food poisoning, rescue, biological attacks, bombing, water shortage, power failure, and others. Regular dry run to ensure that the contingency plan would be applied to the later regular dry run shall be conducted taking into consideration the actual strength of the jail per ship and the absolute reaction of personnel on off duty upon notice of the disturbance. Regional and provincial officers of the jail bureau shall adopt its own contingency plans on how to react upon notice of any disturbance in the jail and on its own office. The same shall likewise conduct a regular dry run to ensure effective and well-organized reaction. Correctional authorities must be guided by the observed in due course the following. Those whose maximum sentence is below 3 years to serve time in local jails. Those whose sentence is below 3 years but those sentence includes a fine or more than 2,000 pesos for transfer to National Penitentiary. Those whose maximum sentence is more than 3 years for transfer to the National Penitentiary. Those whose cases still under trials to await judicial verdict in local jails or under bail. In some situation where national security reasons of court rules are revoked, the persons may be transferred to the National Penitentiary subject to orders issued by competent authorities such as the President, Congress, and courts. Those who commit violation in parole or executive clemency for transfer to the National Penitentiary to serve the remaining portion of the penalty. Those who are captured, escape from the National Penitentiary for transfer to the National Penitentiary to serve remaining portion of penalty along with the penalty of evasion. Movement transfer of inmates. Prisoners or detainees may be moved or transferred safely and humanely by trained personnel who shall adopt the necessary level of security supervision and control to ensure public safety under specific circumstances outlined below, subject to the conditions set forth in the succeeding section and the virtue of an appropriate court's order. An inmate may be brought out of jail under any of the following instances. To appear as witness before any court of justice or prosecution office during preliminary investigation, arraignment, or hearing of a criminal cases. To appear a witness in any investigation or formal inquiry being conducted by government agency. To view the remain of disease relative within the second degree of affinity or consanguinity and to undergo medical examination or treatment in the hospital or clinic. Privilege of detainees and sentenced prisoners. Right to be free from personal abuse and right to be protected against the following: any deprivation of his basic needs under normal situation, corporal punishment, right to good conduct, time time allowance or GCTA for good behavior, right to have access to the following as far as practicable: A. Medicine and health services. B. Rehabilitation program. C. Visitation, conjugal and male services. D. Free legal services and materials. 4. Right to exercise his religious belief. 5. Right to air grievance and complain through proper authorities. 6. Right of women offenders to be formally attended supervised by women officer without prejudice to male doctors, nurses, and social welfare officers from carrying out their professional duties in the institution for women. Right of foreign nationals to communicate with their diplomatic and consular representative. Regional Rehabilitation Center for Youth. The RRCY is the facility is designed to provide intensive treatment in residential setting for the rehabilitation of children in conflict with the law, or CICL, whose sentences have been suspended. It serves as nurturing out of home placement for children it need of rehabilitation. General objective: to render treatment and rehabilitative services to children and conflict with the law, or CICL, or in the different regions in the Philippines to enhance their psychological, emotional, and psychosocial well-being. Specific objectives: assist the CICL in gaining insight into their behavior and attitude to help them become more productive and reasonable individuals. Redirect their behavior and attitude to help them become more productive and responsible individuals. Provide opportunities to acquire social, occupational skills and improve self-image. Provide activities that would help them develop trust for other persons. Target gentle, target clientele. The target clientele are CICL age 15 years to 18 years and not more than 18 years old male who have committed an offense and ordered by the court undergo rehabilitation and DSWD facility, or CR or RRCY. The Child, Youth and Welfare Code. The child is one of the most important assets of in the nation. Every effort should be exerted to promote his welfare and enhance his opportunities for a useful and happy life. The child is not a mere creature of the state, hence his individual traits and aptitude should be cultivated to the utmost as insofar as they do not conflict with the general welfare. The molding of the character of the child starts at the home. Consequently, every member of the family should strive to make the home a wholesome and harmonious place, as its atmosphere and condition will gently influence the child's development. Other institutions like the school, the church, the jail, and the community in general should assist the home and the state in the endeavor to prepare the child for the responsibilities of adulthood. The death row refers to incarcerated persons who have been sentenced to death and are awaiting execution. But the Philippines already abolished the death penalty. In April 2006, President Arroyo commuted the sentence of 1,230 death row and ultimately signed Republic Act 9346 in June 2016, which abolished the use of capital punishment. Congress had overwhelmingly supported the abolition of the practice in their vote for the Republic Act earlier that month, replacing the death penalty with life imprisonment and reclusion perpetua. The role of the writ of amparo. The petition for a writ of amparo is remedy available to any person whose right to life, liberty, and security is violated or threatened with violation by an unlawful act or omission of a public official or employee, or of a private individual or entity. The writ shall cover extralegal killings and enforce disappearance or threats thereof. Who may file? The petition may be filed by the aggrieved party or by any qualified person or entity in the following order. First, any member of the immediate family, namely the spouse, children, and parents of the aggrieved party. Second, any ascendant or collateral relative of the aggrieved party within the fourth civil degree of consanguinity or affinity, in default of those mentioned in the preceding paragraph, or any concerned citizen, organization, association, or institution, if there is no known member of the immediate family or relative of the aggrieved party. The filing of a petition by the aggrieved party suspend the right of all other authorized parties to file similar petition. Likewise, the filing of the petition by an authorized party on behalf of the aggrieved party suspends the right of all others observing the order established herein. So that's all, and thank you.